All right, but we'll set up that protocol. Yes, Ms. Nandi.
My lords, I filed a 3-page note.
Yes.
We didn't keep it to 1 page, my lords, though we could have, only because for the convenience of your lordships, we wanted to reproduce the paragraphs that we are referring to rather than jump between.
So, Ms. Nandi, what are the submissions? Can you formulate your points?
Yes, my lords. My lords, I seek a declaration that includes my rights as queer, non-heterosexual and same-sex people to marry under the secular legislations, the Special Marriage Act, the Foreign Marriage Act, and provisions for OCI card holders only under the Citizenship Act. My lords, I will briefly go through what I will be covering and then go to the last point first. Number 1,
OCI card.
Special Marriage Act deals with...
Volume 7 hai kya?
This tabulated form?
Even I have a tabulated. Submissions dated 26
that's all I have.
23.
There are 2 tabulated forms. One is 26 form.
No, there's just this one form, my lords.
Both justice.
pages.
Both justice.
The cover page is 1 page. The submissions are
I
3
got the
pages.
same thing.
Summary of arguments.
That's 3 pages, right?
It's 3 pages.
Summary of arguments.
The cover page is 1 page, so the PDF may be showing 4. But it's in bullet points. We all have our preferences, my lord.
Yes,
It
yes.
fell from my lord's
Brother
hand.
Bhatt, you have those 3-page submissions?
I have a 6 or 7 page, 6 or 7 pages. I don't know.
It says submissions dated 26/4/2023, correct?
Yes, my lord.
Yes.
The 12 pager and
It will be in compilation 1, volume 7, my lord Justice Bhatt.
Yes, volume 7.
My lord Justice Kaul has it.
I have it.
Ravi, do you have it? Brother Bhatt, do you have it?
I don't know whether I have volume 7.
It was.
You know, it says submissions dated 26/4/23, 2023. ये renumber किसने किया है actually?
It's a table, my lords.
Yes,
It's a table with bullet points.
217 KB.
Why don't you email it to Justice Bhatt? Brother Bhatt, the court will just email it to you.
Where is it? Is it in liquid text? Now you've given.
Justice, but I have mailed it to you.
Okay. Yeah. Yes, I have.
Got it? Okay.
Yes, yes.
Grateful, my lords.
All right.
So, my lords, I am seeking a declaration that includes my rights as queer, non-heterosexual and same-sex people to marry under the secular legislations, the Special Marriage Act, the Foreign Marriage Act, and provisions for OCI card holders under the Citizenship Act that constitute a self-contained part to grant entitlements based on registration, recognition of foreign marriages. My lords, I will briefly describe the first 2 sets of points and then deal with the third first. Because nobody has
Now
dealt
let's
with
see
the
the
third
summary of submissions.
yet. I beg your pardon, my lord?
Let's go through the summary of submissions now.
Yes, my lords. First, my lords, under the Special Marriage Act, it has been submitted that 99.9% of people fall in the gender binary and are men or women, whether they are queer or trans or straight. My lords, we adopt the other arguments of Dr. Singhvi, but my lords, on this point, we differ. The 2011 census itself showed that there are at least 4.8 million, and this is a huge underestimate, my lords, of trans people in this country. Many of them, my lords, are in this courtroom, and I mention this because of the way that they have been demonized in the public. Ms. Muskan Tibrewala, who has rendered excellent assistance, is one such person who is going through a coming out space and has given this permission.
Your first point is you have referred to Section 3 and Section 2K.
Yes, my lords.
The 3 speaks of non-discrimination, against non-binary persons. That's fair enough.
Yes.
Then the next point which you were saying, that is, just explain that. You say that Rule 5 of the transgender rules already recognizes marriage of trans persons. What is the, can you read out the rule for
My
a
lords,
second?
there are the rule.
Is a rule in that book?
Can I have the rule?
Sure, I think
Rule is in the
the
book.
rule-
Can I have rule 5?
Yes, it is, rule is there.
Where is it? It's not 3 pages. No.
Yes, here it is.
Rule 5, right?
Yes, my lords. My lords, Rule 5 refers to the application for certificate of identity. Do my lords have it?
Yes, we do.
No, but Rule 5 is issue of certificate of identity, right?
What? 6 is issue of certificate of identity, my lord.
No.
No, 5.
5.
Take time to down.
We have the 2023 Act, my lord.
No, we have a 2020 rules.
I mean, we have the 2023.
Same rule.
So, yeah,
Rules have changed.
2020 rules.
The
If
Act.
you're saying they're 23,
I beg your pardon, my lords.
rules are 2020, right?
Issue of certificate of identity for a transgender person under Section 6.
No. 6 is procedure for issue of a certificate of identity. 5 is issue of certificate of identity. Right?
Yes, ma'am.
Which one are you looking at? 5 or 6?
My lady, under these two rules, a certificate of identity is issued to trans people.
Yes.
In that regard, an affidavit is required to be submitted, and the form of that affidavit is provided in the rules itself. So it is the forms that I am on more than the rules. The rule is the power
Right.
to issue the form, and I am now on the form.
But when you say Rule 5 already recognizes marriage of trans persons, where do we get that from? Because that's
My
an
la-
important point.
My lord, it's more that the form acknowledges.
Where is the form? Which page is the form?
Form is at page 3224.
No, it's here also in the
Yes,
your
ma'am.
form number.
Justice, in page 17 of this act, if you
Or
have
the
it,
form is
Form
at
Actually,
Form
Justice,
5.
I think let us focus on page 17 of the Act.
I beg
yes.
your pardon? Oh. I'm sorry, my lord Justice. I can't see the judge.
You have the enactment, so you can see the Act. Page 17 contains the form.
Yes, that's what it is. Form 1,
Right.
Yes, form 1.
2D, 3.1 and 6.1. So we suppose this is the form you are relying upon to say that.
The next
it
page, my
recognizes
lords,
the
is
con-
Form 2. I have page 19. I have the 2023 Act.
That's fine.
It's a 20.
23 Act.
What
There's
is
no 23 Act.
23 version.
2019 Act.
2023 version.
Yeah.
It is the 2019 Act.
Right.
But because I'm referring to page numbers, this is the version that I have.
Form 2.
Form 2. Form 2, do my lords have it? It says,
We do.
the form of affidavit to be submitted by a person applying for certificate of identity for transgender persons under Rule 4 of the Transgender Persons Protections Act Rules 2020, read with Section 6 of the Transgender Persons
Most
Protection
important is
Rights
I
Act.
perceive myself as a transgender person whose gender does not match with the gender assigned at birth.
Yes, my lords. I declare myself as transgender.
Right.
But the top part says, I, so and so, son/daughter/ward/spouse of.
Right. So a person who is already in a marital relationship
Yes.
can therefore seek a gender reassignment, like
Or
by
a
virtue of form.
self-declared identification. Precisely what has fallen from my lords. Indeed, as my lords Justice Bhatt had said, some people may seek a divorce pursuant to this. Many people in our society will not. And there is no bar in this regard in the Act, and the Act is
So
silent.
it already recognizes say a pre-existing marriage of a person who is trans.
My lords, the pre-existing marriage, but also the subsisting marriage. Because when
Right,
they
right,
transition
pre-existing,
and after they transition, it continues to subsist.
Correct. There is no bar in law.
Right.
Then there is no bar in law.
Somebody who seeks to assert their identity as trans
Yes.
may well be in a marital relationship at the
Precisely.
point of time when they assert that identity.
Yes. But they also continue to be in that relationship.
Right.
And that relationship under law is not dissolved or annulled or taken away from them.
Yes.
The law accommodates it because these are not grounds for nullity or divorce by the other spouse, because there are possibilities, various married possibilities, that there could be children, there are dependent families. So there's general acceptance. If somebody has a problem, they will seek out in individual cases whatever needs to be done.
I'm grateful, my lords. That's exactly our point. My lords, there is another mention of this in Form 6. And the illustrative list of documents on the next page includes a marriage certificate at item 12.
No, this applies only for both this, and Form 2 will apply to married people who seek that identity as transgenders.
Precisely, my lord.
Right? These forms accommodate such people.
Yes, my lord.
The rule makers have contemplated situations where people seek this gender role, or rather regender themselves, if one could use that expression.
Yes, my
To
lord.
this extent, they recognize and acknowledge that there could be pre-existing marriages.
Yes, my lord.
Mr. Nandi, is it your case that because the rules recognize the concept of a pre-existing marriage in such a scenario, that itself amounts to a permission to have a marriage after such change? Is that what you are seeking to? So, see, there is a pre-existing relationship which will continue. As Justice Bhatt said, it may not dissolve because there may be many ramifications which may arise from such declaring the marriage a nullity or something. So it accommodates that viewpoint. But does that imply that after change, if suppose you are unmarried and there is a change, you can marry? Is that what you are trying to say?
No, that would be my set of arguments that I have made in my larger written submissions, my lords, on constitutionality and harmonization. But, my lords, that is precisely right. What I am saying right at this point is that the state already recognizes, through delegated legislation and the forms that have been issued under that delegated legislation, some trans marriages, and that some at the moment is restricted to marriages that were pre-existing prior to my declaration of identity.
Let us be clear.
Transition biologically.
The marriage recognition is
Yes,
between the marriage was solemnized at a time when both parties were not trans. Neither of them were trans.
True. But it subsists because there is no bar in law as had fallen from my lords.
Let me come. Perhaps there is no ground for divorce in marriage laws. Therefore, there is a recognition of the fact that once somebody finds himself in this situation, we will not disturb it. Because once you start disturbing, there could be other consequence. So you recognize that situation.
Yes,
That is one thing to accommodate in the form of rules or even forms. No, we are not talking about rules. We are looking at forms.
yes, my lords.
If we are to transform that into substantive provision and work backwards, as it were, there should be some statutory support for that.
Yes, my lords.
Because unless you state that, for instance, Section 3 or whichever provision says there shall be no discrimination, and then goes on to say in what aspects, like you have in Section 47 of Disabilities Act. So
Yes,
what are the rights and what are the obligations, what rights of these persons who claim these identities, and what are the obligations of society? The legal obligations are also spelled out. So if your argument is built around these forms, then you'll have to go further.
My lords, the argument is precisely the way that had fallen from my lords, Justice Bhatt. We have said, for example, that it has been said in this court, during these proceedings, that trans and non-binary people are elite, that small portion, etc. My lords, the first point addresses that. The second point is on the non-discrimination, my lords.
Elite argument you can just keep aside because we are now going into the core constitutional issues and core statutory issues.
Yes, my lords.
So, elite is a matter of prejudice. I mean, but it has no bearing on how we decide the matter.
I'm grateful. Let's
Actually, these two forms which you showed us, the first form, Form 2, is at the stage when you apply for a gender identity certificate.
Yes, my lords.
Form 6 is after a gender reassignment takes place. Because if you see Rule 7.4,
With the ID.
Form 6 is to be read with Rule 7.4 because that's that's in the title of Form 6. And 7.4 says the district magistrate, while issuing the certificate of identity for change of gender, shall simultaneously issue an identity card in Form 6 to the applicant.
Yes, my lords.
And that form in item 12 refers to marriage certificate. So these two forms seem to indicate that both when a person applies for a gender certificate in Form 2 and the issuance of a reassignment in certificate in Form 6, they do contemplate that somebody could be a party to a valid marriage because or a subsisting marriage.
Precisely.
The position as it existed at the time of the grant of the certificate is what is contemplated, without anything more.
But also, as my lord, the Chief Justice had pointed out, that after the gender reassignment surgery is done, the situation is different.
Correct. This is
And then,
No, but Ms. Nandi, if you see the Act also,
yes, my lady.
Section
Yes, indeed.
5, 6, they refer to application for certificate of identity. They refer to issuance of certificate. 7 talks of change in gender and specifically says that it is, if you will read that an application may be made along with the details of the institution where the person has undergone surgery. So the whole idea is so that the certificate can be revised. The context is of 4, 5, and 6 is issuance of certificate of identity.
Yes, my
In the course of that,
Yes.
the status of that person, as it were, is reflected from one of the columns, but that's about it. So how do you propose to take it further?
My lady, the
Build your
point is this. My lady, what I am saying is this, is that the law recognizes under Section 2K the range of gender identity. In Section 3, if we may come to that, (3)(e) specifically,
Yes, please.
prohibition against discrimination, 3E says the denial or discontinuation of or unfair treatment with regard to access to or provision or enjoyment or use of any goods, accommodation, service, facility, benefit, privilege or opportunity dedicated to the use of general public or customarily available to the general public. So it's a broad non-discrimination provision. In addition, and this is my third point, that this is not happenstance.
You're right, it's not happenstance.
Because of Nalsa, my lady.
But then this is a right which is available under 15.2 to some extent.
Precisely, I'm grateful to
Don't
my
need-
Lord's Justice Bhatt. This is
Don't need a NALSA. 15.2 encapsulates that. It's a wide horizontal right, right? So, I mean, to take your logic, let us go to Rule 5. Rule 5 talks of issue of certificate of identity. Right? It says the certificate, number 3, sub-rule 3, certificate of identity issued under sub-rule 1 shall be the basis of change of gender as well as the name and photograph if so necessitated in all such official documents as provided in Annexure 1. Now, what is Annexure 1? We don't have that in this.
Annexure 1 is perhaps what is at page 23. It refers to Annexure 1, brother. Card issue date, signature
Annexure 1 is there,
Annexure
same
1's
thing, the
illustrative list of official documents referred to in the name of the official document.
It's titled Annexure 1, as my lady has pointed out, above the table.
Page
Part of
23.
Form 6. It is Annexure 1.
No, it's not.
It's a part of Annexure 1.
Annexure 1 is not part of
No.
Form 6, it's an independent annexure. And this is something relatable to Rule 5.
Yes.
So, just to take the thought further, Ms. Nandi, not
Yes,
everyone
Manoj.
has a marriage certificate. Not everyone has a marriage certificate.
Yes, my lords.
You agree?
Yes, my lords. Not everybody has a marriage certificate. Some transgender marriages continue to subsist.
No, I'm not talking of that. I'm talking generally.
Yes, my lords.
Matrimonial,
Yes. Not everyone has a marriage certificate.
because marriage certificate is a civil kind of form which is not mandated by any personal law. There is no compulsion except maybe in some states
Absolutely.
certificate. The only
Absolutely.
certificate which is mandated is under the Special Marriage Act, because that is the only form of marriage between those two classes of persons who belong to different communities, right? So a marriage certificate itself might pose a problem for anyone.
Yes, my lords.
Yes.
My lords, I am only pointing out the current situation. I'm
Yes.
pointing out that currently that there are some transgender marriages that at the point of transition are recognized to subsist. There are other transgender marriages that are not. Either they do not have the marriage certificate, or they cannot marry the person they love only because of the timing. That is my point, my lords.
See, that point is, you have made your point, but the point, there is a distinction, which is that those who are married as not transsexuals, as heterosexual couples, a heteronormative based marriage, so to say, later turns out to be one where one recognizes her gender not as a female or male, but as a transgender person. At that stage, the law enables this much, and it also does not upset the pre-existing.
Yes, my lords.
Exactly.
Now, your dilemma is the next step, which is that having recognized the pre-existing relationship, you have not enabled two transgender persons to come together and celebrate their union in
Yes.
matrimony. That is your dilemma.
Yes, my lords.
Where you're saying, no, you can't locate that within the enactment. To the
We are
extent
not.
that
We
the
are
law
not.
recognizes this,
Purpose of
but you have to go beyond that, and there you have to fall back on the same arguments which are made by your predecessors.
By many counsel before me and by me, but I will not repeat them in the interests of brevity, my lords. But that is precisely, my lords, what our burden is, to discharge the burden of constitutionality as it relates to the argument that goes beyond the forms. And my written submissions, my longer written submissions, which is in compilation 1, address all of those arguments as well, my lords.
What is the next point?
The next point, my lords, is just to say that this is not happenstance, that the Transgender Act of the Union, not so long ago, only 4 years ago, was enacted pursuant to NALSA. And what NALSA says at para 119, and I've reproduced the part for convenience, that therefore gender identity becomes a very essential component which is required for enjoying civil rights by this community, viz. the right to vote, the right to own property, the right to marry. On workability, my lords, on workability, I have worked it out, and my respectful submission is that there are only two doctrinal principles that need to be applied for a minimal reading in. The first is this, that husband and wife should not be collapsed into the same category, my lords. And there should not be one gender-neutral category of spouse. Because the heightened protections that are given to women emerging from Article 15(3) are there for a reason. So what we have proposed in this note, but the reason we didn't file it because we would like to hear what the other side has to say, but this is the current formulation. Is that third gender spouse, which is a phrase used in NALSA. It has been critiqued. So non-binary can also be used in this regard. May be used along with husband or wife. And of course, husband or wife must include trans husband or wife. As the Madras High Court did for the Hindu Marriage Act in Arun Kumar, that judgment is in my compilation. I'm not going into it because it's the Hindu Marriage Act. But that's the way the Madras High Court had worked it out. The second doctrinal principle, my lords, is this, that
can you send this on email to the court master so that he can then email it to justice?
We will do it in the next 10 seconds. We weren't planning to hand it over, my lords, but...
So you are saying, I'm sorry, Ms. Nandi, there was a lag here. I think perhaps Justice Kaul also.
Yes, my lord. Shall I repeat what I said, my lord?
First you said that you do not want a neutral phrase like spouse. You don't want to collapse the gender.
Basically,
because
the Bhatt and Justice Kaul.
Yes.
What Ms. Nandi's tabulated statement which she has given us now,
Yes.
seeks to interpose the word or third gender person in various provisions of the Act, including Section 2B. So, for instance, in 2B, she says a man or third gender person. Likewise, a woman or third gender person. In Section 4, which deals with conditions relating to solemnization of special marriages, the male has completed the age of 21 years and the female or third gender person, the age of 18 years. Likewise, in Section 12, I so-and-so take B to be my lawful wife or husband or third gender person. So, then spouses instead of husband and wife. In Section 15, husband or wife or third gender spouse in Section 22.
So I think it goes on then.
That goes on, exactly.
Just to emphasize, my lords, that I used third gender because it comes from NALSA and it has precedent in law. But it has been critiqued by the communities. And so non-binary would serve just as well. Non-binary person or non-binary spouse.
Ms. Nandi, so then you comment that the approach of the Madras High Court should be adopted in regard to all this. We understand that. The only question is, where do you perceive the conflict between your position and the position by the predecessor council? Because that is something we have to iron out.
Yes, my lords. My lords, the Madras High Court supports this workability note only to the extent that man or woman includes trans man and trans woman. What we have added here, my lords, is non-binary persons based on two doctrines: differential protection for women to be preserved, and that heightened protection also be provided to non-binary transgender persons due to the fact that, in line with Article 15.2 to 15.4, NALSA requires the Union to provide special provisions for transgenders and affirmative action as social and economic backward classes. So there is a ground, because of historic discrimination, in para 67 and 68. Read out the paras. This is at volume 1. Shall I come to that, Manoj?
Yes.
This is volume 1, compilation 4, PDF 792 and paperbook para 761. I am on para 67. Transgenders have been systematically denied the rights under Article 15.2, that is, not to be subjected to any disability, liability, restriction or condition in regard to access to public places. Transgenders have also not been afforded special provisions envisaged, and my lords may note envisaged already, under Article 15.4 for the advancement of the socially and educationally backward classes, SEBC, of citizens, which they are, and hence legally entitled and eligible to get the benefits of SEBC. State is bound to take some affirmative action for their advancement, so the injustice done to them for centuries would be remedied. Transgenders are also entitled to enjoy economic, social, cultural, and political rights without discrimination, because forms of discrimination on the ground of gender are violative of fundamental freedoms and human rights. Transgenders have also been denied rights under Article.
All right, Ms. Nandi, we've seen Nalsa. Now, should we go back to your statement actually, so that that's page 2, so
Yes,
that we can just look at it and then we can wrap up, I think.
My lords, I have two additional points, if I may, and my third point is one that nobody else is raising.
Yes.
So I'll go through this very fast and then come to my third point.
Yes.
So 15.2 to 15.4, my lords.
Where are you reading?
Differential.
Where are you reading in your
Part of the statement are you on?
which page? Which page of your statement?
I finished page 1 and I am turning to page 2 to deal with the Foreign Marriage Act.
Yes. Okay.
My lords, should this court
26.
only read the Special Marriage Act inclusively, an immediate Article 14 anomaly will arise. The statement of objects and reasons in the Foreign Marriage Act explicitly and repeatedly states that the FMA is pari materia to the SMA and incorporates provisions of the SMA by reference. So the FMA applies when one party is an Indian citizen and the marriage is solemnized outside India. So for clarity, it doesn't apply to two foreigners. However, the same Indian foreign couple may come to India to marry under the Special Marriage Act, because the judgment that I have placed on record, and I've only placed one, it is of 2023 by Justice Pratibha Singh, and she has detailed the other case law that also says the same thing. And it holds that even two foreigners, male and female, can marry under the Special Marriage Act, because Section 4 uses the term any two persons and not citizens. So if the Foreign Marriage Act does not follow the Special Marriage Act in being read in a gender-inclusive manner, same-sex, queer, and transgender couples may marry in India, my lords may scratch out or at a consulate, may marry in India, but if they are already married on foreign soil, they will not be able to have their marriage registered by an Indian marriage officer under the Foreign Marriage Act, Section 17. The reason is that 17 refers back to Section 4. And Section 4 is the only place where gender-specific terms bride and bridegroom have been used. And we have done this workability exercise, my lords, and placed the Foreign Marriage Act provisions also under the table that we have submitted to my lords. We will refine it if required, if there are submissions in this regard from the other side. But my lords, the rest of the Act, if Section 4 is read inclusively and in accordance with a declaration or the Special Marriage Act, falls almost automatically into place.
So then now your final point, which is...
My final point is that there is a third category of persons. And this third category of persons are represented only in my petition. They are left in a catch-22 situation. We are married OCI persons with families who choose to live here. Some of us, and some who have deep roots in this country. Many have been Indian and then moved abroad and... I beg your pardon? And become OCI. They cannot marry under the Special Marriage Act because the third schedule requires a declaration that one is not married. They cannot marry under the Foreign Marriage Act because that only applies to an Indian citizen marrying a foreign citizen.
Who is there before us with of that category?
So before you, my lords, are Kamakshi Raghavan and Melissa Ferrier.
Want to see if any of those people fall in the category that you are mentioning.
Yes, my lords. My lords, if I may have the leave of the court to say a little bit about Kamakshi Raghavan and Melissa Ferrier.
You said that they cannot marry under the SMA because the third schedule applies to persons who are not married.
Yes.
And they cannot marry under the FMA because?
One party must be Indian and one party must be foreign. Here, for my petitioners, one party is OCI and a foreign citizen, and the other party is foreign. And if I may tell, as had fallen from my Lord Justice Bhatt, just a little about Kamakshi and Melissa.
Yes, we can. Can we decide constitutional validity on individual cases? You know, I mean, validity of a provision doesn't become suspect because of, it causes injustice in individual cases. You have to look at the constitutional validity of a provision from the larger perspective.
Shall we look at the plain words of the provision, my lords? But first, if I may tell my lords a little bit about this couple.
See, we have...
With my Lord Justice Bhatt's permission, if I have time in the end, shall I do that? And shall we go to the section itself?
Classical statement of law was by Justice Krishna in R.S. Joshi versus Ajit Mills, that you know.
My lords, I am on constitutionality. Hardship is only a supportive argument. And constitutionality...
My question was not an invitation to outline the facts. Because when we are deciding, none of the previous council have outlined any facts. Except the barest minimum. Because if we are to, then we would delegate this matter somewhere else. So tell us how the only thing, one sentence, how is it relevant or is it not in your petition? If it is not, it is moot. Why should we decide it? If it is, then you say so and proceed. That's all.
So why don't you summarize now, as we are concluding, give us the core of your submission. Why don't you summarize it now so that we can then note it and then we'll conclude.
Let me summarize my submission with regard to the Citizenship Act. As had fallen from this Honorable Court and from Justice Bhatt in particular, that is there a segregable provision with no prohibition in the enactment in which certain things which can be done straight away without entering other arenas in enactments where there is no express prohibition of the remedies sought. I have reproduced Section 7A1D of the Registration of Overseas Citizens of India card holder in the note itself. My Lord, we have also requested the Courtmaster to keep the Act ready. The provision is clear, if I may.
To civil courts and to the high courts with questions of statutory interpretations as they raise claims and they seek the protection of law in the same manner as opposite sex couples do and have done now, perhaps since the codification began of matrimonial laws starting from the early 1800s onwards. So we are no different in that regard. In fact, if I may say, what we ask for today is the right to not be different, that our differences stand ameliorated by our inclusion under this one statute. So what your lordships have said so far is that the application of the Special Marriage Act would be expanded and then it would apply to us as it does to all other couples. That, my lord, is my submission, would continue to be the reading for 21A and for other general civil laws. And what I would submit, my lord, is that a declaration, both a positive declaration in the form of mandamus and a negative declaration in the form of prohibition, would go a long way in easing the work of the courts below in the interpretation of the statutes, as they must now commence doing in the work that they will have to come. If my lord will see, I have set out that declaration at the very beginning of the note. It is first, my lord, do my lords have it? In paragraph 3.
Paragraph 3. Yes.
My lords have it? Justice Kaul and Justice Bhatt?
Yes.
I'm obliged. I'm obliged. So we seek, my lord, first the positive declaration that a marriage solemnized or registered, it would be solemnized, I apologize. Marriage solemnized under the SMA 54 and the parties to the said marriage shall be entitled to all the rights and obligations conferred on a married couple or a party to such marriage under any other state or central law, notwithstanding the gender identity and sexual orientation of the couple. And your lordships would also, I propose, give a negative declaration binding the state that the state nor any authority of the state shall deny rights and obligations conferred on a married couple or such party, and then the formulation is the same under the Special Marriage Act only on the grounds of sexual orientation or gender identity.
Yes.
With this groundwork in place, my lords, I'll now come to the first question which fell from your lordships yesterday. And my lords, let me say, it is not a light question. It is not a question to be easily decided. It is not a light question for us to consider either, to contemplate. As far as Section 21A is concerned, I would first submit that on a statutory reading, in terms of the application of the principles of statutory interpretation which your lordships will consider, 21A will apply to same-sex or LGBTQ married couples who marry under the SMA in the same manner and with the same force as it would apply to an opposite-sex couple. Now, for my lord's convenience, I have actually set out the section in the note itself, but we can take it from the statute as your lordships prefer. May I read for your lordship's benefit? It's, my lord, at page 5 of my note. There's a table set out, but otherwise, if my lords have it, I'll just go ahead. Special provision in certain cases. Where the marriage is solemnized under this act of any person who professes the Hindu, Buddhist, Sikh or Jain religion with a person who professes the Hindu, Buddhist, Sikh or Jain religion, section 19 and 21 shall not apply, and so much of section 20 as creates a disability shall also not apply. Now, my lord, let's read the chapter starting from section 19. Section 19, my lords, the marriage solemnized under this act of any member of an undivided family who professes the Hindu, Buddhist, Sikh or Jaina religions shall be deemed to effect his severance from such family. And let me say, my lords, that the membership of such a family is not something which we take lightly. It is an important part, my lord, of the way in which we see ourselves as members of the family and as society. But, my lord, section 20, subject to the provisions of section 19, any person whose marriage is solemnized under this act shall have the same rights and shall be subject to the same disabilities in regard to the right of succession to any property as a person to whom the Caste Disabilities Removal Act 1850 applies. I'll take my lordship to the Caste Disabilities Removal Act also. Section 21. succession to properties married under properties of persons married under the Act. Notwithstanding any restrictions contained in the Indian Succession Act with respect of its application to members of certain communities, succession to the property of any person whose marriage is solemnized under this Act and to the property of the issue of such marriage shall be regulated by the provisions of the said Act, and for the purposes of this Act shall have effect as if Chapter 3 of Part 5, special rules for Parsi successions for interstate, had been removed therefrom. Now, my lords, what is the overall effect of this chapter? Firstly, upon marriage of a Hindu, Buddhist, Sikh or Jain to a person who, in light of Section 21, is not a member of that faith, you are severed from the joint family. Secondly, my lord, these disabilities and this Caste Disabilities Removal Act, my lord, of 1850 is saved under Section 20. Thirdly, my lords, I am removed from the operation of the Hindu Succession Act if I marry a non-Hindu, and now placed under the Indian Succession Act, as fell from my lords yesterday. But 21A, if we come back to it, it has the effect firstly of saying that 19 and 21 will not apply to me if I marry another Hindu. And secondly, it does not apply to non-Hindus, that is persons of other religions who may marry within their faith. But 19 and 21 apply to those persons.
Ms. Kaju,
My lord.
I think there is one caveat there.
My lord.
Whereas you are right on the first part, the second part will have to be seen closely. Because you are presupposing that there could be other two same-sex couples from the same religion.
My lord.
You have a Christian and a Muslim.
My lord.
Christian and a Parsi, or a Jew and a Muslim, or whatever. So all limitations are there, which means to that extent you will have to look into the provisions of the Succession Act, concerned provisions of the Succession Act to start with, and other personal laws. Now that is one complication. And the second is, you are very right in straight away stating that the Hindu Succession Act will apply, or whatever laws of Hindus will apply to same-sex couples who are both Hindus. But that means necessarily, willy-nilly, we will have to interpret. And then, like all of you keep repeating, life doesn't wait. So if there is an unforeseen circumstance like an accident in the absence of a will, or something else, then necessarily the spouse stands excluded. Either Section 8 or the rules of succession of females, or we don't know what other complications are there in other provisions.
And may I say, my lords, perhaps today we cannot know. And we must, I say this with all humility, having considered various aspects of this matter for many years, that all aspects of or questions which may arise before the courts are not clear to us today, as they are not in any case. Your lordships have time and again gone back to the institution of marriage as codified under various statutes and read in various nuances which arose with the passage of time. So as fell from my Lord Justice call, these questions we will be here time and again. But as far as this question which my Lord Justice Bhatt raised, yes, there will be couples who are LGBTQ and my lords who are interfaith couples. And there, my lord, 21A will apply to them as an interfaith couple. And there will be couples, my lord, who are Hindu and LGBTQ. And there, my lords, 21A will apply to them as a Hindu couple. Your lordships are not required today to further read the Act beyond reading in and explicating the word spouse.
We look at,
my lords,
yes, Miss Kaju.
My lord.
Then jurisprudence of this court, which has with provisions of law and their constitutionality, has never isolated one provision. To take it to minorities in the field of education, when an enactment is there, the organic whole has to be seen in the context of a challenge to the concerned provision.
The
Old Control Act, which was seen in the 60s, or even Frank Anthony, which examined the entire provisions of the Delhi Education Act to see the impact on one section. So there is an organic whole. So to isolate one would not be in consonance with this, the approach of this court. That would be leaving things half done, mostly undone. Therefore, how this has to apply will have to be ultimately taken on by us at one go. That's one way of looking at it. All of you have been consistent saying that these are battles which will be fought later. But that does it absolve us of the duty of constitutional the obligation of seeing and considering doctrinally the impact of one provision over the other, or many provisions over one? That you will, that we will have to keep in mind.
My lords.
All of you have given one picture. That
My
I
lords.
The rest look at only this, and this is what we want.
May I submit?
Actually articulated the positive and the negative part. So I think it, in a way, summarizes the entire, let's say, project.
May I say, my lords, that my lord may be right. As a matter of constitutional explication, the constitutional underpinnings must be taken through to their logical end. But my lord, as far as one provision or the other is concerned, I may say that in my own reading of and research into 21A, aside from one judgment before the Honorable Delhi High Court in 84, we did not find any other challenges, my lord, to the constitutionality or otherwise of 21A. I would submit that it poses no problem because it is a part of the seamless whole of the statute as it stands today, in light of the legislative developments that have taken place since 1850. So if my lords will permit, I'll come to my second point, which is on the evolution of the law of special marriage, which commenced, my lord, in 1872. And prior to that, my lord, we would just shortly consider the Caste Disabilities Removal Act of 1850. So if my lord.
You know the questions that we have asking. You just formulate your points.
My lord.
And then what ideas you have,
my lord,
suggestion you have,
my lord,
you can just
my lord. I'm very
away. You will be able to easily appreciate that.
We wanted the other side to begin at 12. Now I think we can now start. If we can just formulate, we'll ask the others also to formulate 2 or 3 submissions, and then we just.
I bow down, my lord. So if my lords will just briefly consider, then I'll come straight away to the second portion of my submission on 21A, which is the legislative history of the Act. And I'll quickly take your lordship through it. I won't trouble your lords with my note. In fact, the short point is this. In 1850, my lord, the British legislature introduces the Caste Disabilities Removal Act, which says that notwithstanding any loss of caste, excommunication, etc., the laws relating to property and other benefits which flow from customary law will continue to attract to a person. Thereafter, my lords, comes in 1872 the Special Marriage Act, as a result, my lord, as I understand it, of certain demands by Brahmo Samajis who said at that stage that they were not Hindus. And these were live questions, my lord, before the court as to who was included within a Hindu, within the understanding of the term Hindu, and who was not. And therefore, my lord, when the Act came in 1872, since a need was felt, as is felt today, that no community can be without a law of marriage, this statute required that a person give up their religion, surrender their religion, and therefore it's stated, I've set it out in the tables, that table A, my lord, at page 4, that marriage could be celebrated between persons neither of whom profess the Christian or the Jewish or the Hindu or the Mohammedan or the Parsi or the Buddhist religion, etc. So it required me to renounce my religion. Thereafter, my lord, in 1923, comes Act 30 of 1923, which amended the provisions both as to who could marry under the Act, and secondly, my lord, as to the restrictions on personal law which applied. So, my lord, if my lords see, the first part was retained, that for certain communities, they still had to give up professing their religion. But now, the underlined portion, that marriages could be conducted between Hindus, the Buddhist, Sikh, Jaina, Hindu, so and so, or between persons, each of whom professes one or the other of the following religions, That is the Hindu, Buddhist, Sikh or Jain religion. And what we must understand, my lord, is at this time, until the coming into force of the Hindu Marriage Act 1955, this would have been the law for any intercaste marriage. Therefore, my lords, it followed, and I'm cognizant of the time, therefore it followed that, as I've set out in the second table, certain restrictions on the application of personal law were imposed, and at this point in time, it was the most onerous. If my lords will see table B, where I have given the provisions of Act 30 of 1923. Firstly, my lord, in 22, as now, it affects severance from the joint family. Secondly, my lord, the Caste Disabilities Removal Act, my lord. Thirdly, my lord, there were provisions that a man could adopt another son, my lord, in section 26. And my lords, under section 25, no person who adopted under this law would have the right of adoption, who married under this law would have the right of adoption. And under section 24, the Indian Succession Act would apply. Next, my lord, came the Special Marriage Act 1954. And this statute, my lord, is also in 54. We are in the middle of the debates about the Hindu Code Bill. And 1955, the Hindu Marriage Act follows. So now for the first time, there is a unified civil law for the Hindus. There is a unified civil law of marriage for the first time. And under that law, intercaste marriage and intergotra marriage is now permissible. And therefore, the restrictions which are adopted in the application of personal law are modified to those under 19, 20 and 21, which we have today. In 1976 comes the final Marriage Laws Amendment Act, which brings in the provision of section 21A, which now exempts those Hindu couples who marry under the statute from the provisions of 19 and 21. What, my lord, does this history tell us? As far as the application of personal law, since it fell from my lords, as far as the application of personal law is concerned, to a couple who marry, who may be LGBTQ, but who marry within their faith, those statutes which are contemplated as applying under section 21A will continue to apply. That is my submission. Now, what will be the extent of the application? How will those statutes be read? These will be questions, my lord. Courts may hold, my lord, that we are excluded altogether, that there is no provision for the application. But how will those questions arise? In what circumstances? To which persons? Those are, my lords, questions which, as my lord Justice Bhatt perhaps indicated, will arise on a factual basis with the passage of time in different circumstances. But my submission, my lord, would be this, that per se, in my lord's reading of the Special Marriage Act, section 21A must continue to apply to Hindu LGBTQ couples. There can be no per se exclusion of Hindu couples who choose to remain within their faith for the matter of who they choose to partner with. In 50 years, I would submit, my lords, this section has not created any major difficulty with respect to its interpretation to opposite sex couples. And my next submission is this. My lords should not presume and pre-anticipate a difficulty which would arise for LGBTQ couples. On the one hand, the union submits that it would play same-sex marriage or LGBTQ marriage would play havoc with personal law. On the other hand, we tell your lordships that we are part of our societies and our communities. Our parents also long for our marriages just as those parents of opposite sex couples. They long to see that day, your lordships. So let us not assume, yes, there are cases, my lords, where a family may oppose a marriage. Those cases exist for opposite sex couples also. And how have your lordships and the union responded? Your lordships have responded by saying from a series of cases in Lata Singh's onwards that the state is enjoined to protect such couples. And the union has also risen to the occasion. The police protect such couples as today they protect us when we approach the courts. And the state also responds by offering, for instance, under the Dr. Ambedkar scheme, under the Ministry of Social Justice and Empowerment, special schemes to promote intercaste marriage. So, my lord, it cannot be presumed, because today we are going through a process of social change, because today we are at the threshold. Neither this court nor I would humbly submit the state should presume that there is going to be a certain kind of outcome. They should see their people. It is not only a question of elites, my lord. We receive calls and we hear from young people across this country. From the inception of this case, my lord, I have received calls from people in Hisar, in Surat, in Chhattisgarh. When I asked, which district are you from? They said, which district? We are from Raipur, we are from Rajnandgaon. You name it. Let us not assume any more than we would assume at the outset of embracing any section of our society within the fold of law. Let us welcome them. Let the union welcome us and bless us as it would bless any other married couple, my lords. We seek those blessings. So, my lord, my last submission, therefore, is this, and now I promise I will wrap up, is that when it comes, therefore, after we marry, to the application of laws, the application of laws must be uniform for both same-sex and opposite-sex couples. On the one hand, my lord, there are general civil laws. For example, as fell from my lord the Chief Justice yesterday, of gratuity, pension, inheritance, succession, and so on. And my lords, those laws, the word spouse would be read in, the word husband or wife would be interpreted in a gender-neutral fashion. And my lords, where a person would otherwise nominate their spouse of the opposite gender, today we would be nominated as spouses of the same gender. The other question, my lord, is the question of having children. Now, it fell from my lords, and very rightly, my lord, my learned friend, Mr. Vishwanathan, also said that today, perhaps not all couples wish to procreate. Not all couples who marry shall have children, and nor is having children a condition of any law. But my lord, as a couple, as a married couple, having a child is part of the human experience. And it may be something that some also long for. Today, marriage is a gateway for couples to have children as per the legal framework. So under, my lord, the JJ Act, the adoption regulations require that a couple have been married for a certain number of years, that there be a stable marital relationship and so on. This is, my lord, for a couple to adopt. Now, my lord, similarly, under the Surrogacy Act, only married couples may opt for surrogacy with some provisions. And the child who is born of surrogacy is protected under Section 8 in the same way as a child who is born of, let us call it, natural methods or a natural born child. Similarly, my lord, the adoption statutes say that at the moment of adoption, an adopted child, there will be a severance with the biological family, and the adopted child will have all rights and obligations as a biological child does. Now, what is the import of what I'm saying, my lords? There are already couples in this country who have children, LGBTQ couples, and those couples are also before your lordship. In the absence of the recognition of marriage of their parents, what the law does is it renders, just as it renders one partner of the relationship a stranger to the other, it also renders a child a stranger to its parent-in-law. That child has no relationship in law with one of its mothers who may love her equally as a mother in an opposite sex couple, who may do everything from morning to night as a mother does in an opposite sex relationship. But that child, my lord, without the protection of law, without the protection of adoption law, or the provisions of Section 8 of the Surrogacy Act, or similar provisions of the Assisted Reproductive Technologies Act, is rendered a stranger to its parents. That your lordships have held on numerous occasions is constitutionally untenable. A child cannot suffer because of the parents belonging to a protected class under Article 15. This is the sum and substance of my submissions, my lord. I'm grateful for a very patient hearing to this side. I'm obliged.
Now,
Your lord.
we now have four remaining counsel, Mr. Raghav Avasthi, Mr. Shivam Singh, Mr. Namit Saxena, and Mr. Manu Srinath. We would request all four of you to now wrap up in 2 minutes. Or
Your Lordship, Ms. Amritananda Chakravarti. Your Lordship, I'm a petitioner just after Ms. Karju.
yes.
Yeah, I'll just take 10 minutes, Your Lordship. Very brief. I've already given my note, my lords. It's volume 8. It's a brief 1.5-page note, Your Lordship. I've set out my...
Got your note. If you can just make maybe 1 or 2 points now.
Yes, Your Lordship.
What is the...
Your Lordship, I have challenged certain provisions of the Foreign Marriage Act and the adoption regulations. I'm the only petition that has challenged the adoption regulations for excluding same-gender couples and transgender persons from the institution of adoption, joint adoption specifically. Why have I challenged adoption regulations? Before that, Your Lordship, I just want to say that the petitioners, they have been in a relationship for the last 15 years and they have married under the Denmark law on 16th of August 2022. So we are a couple who is married under a foreign law and we are living as a married couple in Germany. And what we want, we are there because of our professional deputation. We don't want to settle abroad. We want to come and settle in India. But we want with our marital status, we want with our joint life that we have built in Germany. So the question on Foreign Marriage Act, I just have one point, Your Lordship. Your Lordship has my note?
Yes. Why don't you formulate it?
Yes. My first submission under the Foreign Marriage Act, Your Lordship, is if not for my